the name of Almighty Allah, the most merciful, the most beneficent. Very good day, and the topic of our today's discussion relates to the legal review of a decision recently made by Pakistan Medical Commission. And in this decision, dated 22nd December 2020, the PMC has issued minutes of meeting wherein PMC has introduced a policy and implemented a decision and stated that MPhil pathology is an academic qualification, and onwards this qualification will not be entered on the registration license issued by Pakistan Medical Commission. Whereas MPhil pathology is level 7 qualification as specified by Higher Education Commission. Moreover, MPhil pathology is an additional medical qualification and not purely an academic degree. In order to review the decision of PMC, I have framed few questions for understanding the exact ramifications of this decision. The very first question is, what is the effect of this under review decision? On the basis of this decision, PMC has refused to enter MPhil pathology qualification on the licenses. On the contrary, PMC still enters Diploma in Clinical Pathology and NCPS of 2 years duration on the licenses, whereas both qualifications are of lower status as compared with MPhil pathology. The second question I have framed in order to explain the state of affairs is that what hardships are caused on account of non-inclusion of MPhil pathology qualification among medical qualification and its non-endorsement on the licenses. There are thousands of doctors practicing in Pakistan and abroad who have adversely affected by the retrospective application of this decision, viz. Their employments are at stake, their future prospects are badly compromised, and there is a possibility that they will even be deprived of their pensionary entitlements and benefits. The third question, which is very important, whether the decision of PMDC is, and now known as PMC, Pakistan Medical Commission, is against the PMC Act itself. Yes, of course. The quick answer to this question, Clause F of subsection 2 of section 8, PMC Act 2020 provides that PMC has to frame regulations for standards of revalidation of licenses. In the present case, PMC has issued minutes of meeting and made a decision in respect of standards of revalidation of licenses without framing regulations in violation of its own law. The fourth question is whether the decision of PMC is against any other provisions of PMDC Act or PMC Act 2020. As a matter of fact, the decision of PMC is in violation of sections 22 and 48 of its own law, which are relevant to postgraduate, additional, and alternative qualifications. Furthermore, this decision is contrary to subsections 1, 2, and 6 of sections 50 of PMC Act 2020. It is also in sheer violation of section 16 of PMNDC Ordinance 1962 and Schedule 3. The decision of PMC is against the mandate of section 6 of General Clauses Act. And I'd like to explain here that why I have quoted PMNDC Ordinance 1962's relevant section, because there are number of professionals who earned this qualification when PMNDC Ordinance 1962 was in vogue, and on the basis of relevant provisions, this qualification was included in their licenses. But subsequently, while applying this decision and making the application of this decision applicable retrospectively and of course prospectively, they have now declared that they will not make endorsement of this qualification on the licenses wherein in the past these inclusions or insertions or endorsements were made. Now, the second question, in order to understand this topic, is whether the decision offends any of the fundamental rights of holders of MPhil pathology qualification. In order to address this question, the decision under review is made in utter disregard to the Articles of Constitution, inter alia. Article 4, every citizen has to be treated in accordance with law. Article 9 says, right to livelihood. And finally, Article 18 precisely states right to profession. So this decision is causing infringement and violation of these fundamental rights of all those who have earned this qualification, who have received the licenses on the basis of this qualification, and who have commenced their studies in order to attain MPhil pathology qualification. Now, the next question is whether there are superior court's judgments which enunciate the principles for the fundamental rights as enshrined in the Constitution. Yes, there are numerous judgments which laid down the principles pertaining to this list in hand, and these are PLD 2021 Lahore, page 436, and these all decisions, including 2020 Supreme Court Monthly Review, page 1069, which are based on a judgment which is a parent's judgment on the subject matter, that is PLD 1997 Supreme Court, page 315. Now, the next question is whether the policy decision of PMC transgresses an important principle of justice. Yes, ironically, this is the scenario. The decision under discussion, hit by doctrine of judicial estoppel as developed through an authoritative judgment rendered by Honorable Lahore High Court Lahore and reported at PLD 2017 Lahore, page 68. Now, the next question is whether this decision of PMC is discriminatory vis-a-vis DCP and NCPS qualification holders. Yes, indeed. PMC still enters Diploma in Clinical Pathology and NCPS on the licenses, whereas both qualifications are of lower status as compared with MPhil pathology. This act of PMC is absolutely against the equality principle as enshrined in Article 25 of the Constitution. It is also against the latest judgments rendered by the Honorable Superior Courts. Especially, I quote here and places my reliance on 2000 Supreme Court Monthly Review, page 1956, and 2017 CLC, page 1683, Karachi. Now, the next question, which is the last question. The application of this decision is retrospective, and those who have received this MPhil pathology qualification are serving for last many years on the strength of their MPhil qualification, which was entered in their licenses. Whether this retrospective application is against the well-settled principles of law, actually, on account of this retrospective application of the under review decision, the established and accrued rights of MPhil pathology qualification holders are curtailed. The superior courts have already deprecated and denounced these sorts of decisions made in the past by the regulators. Especially, I places reliance on 2021 PLCCSN, page 57, 2020 Supreme Court Monthly Review, page 1069, and the parent judgment, that is PLD 1997 Supreme Court, page 315. So, in order to conclude today's legal review on the subject matter, I will precisely say that this decision of PMC is not only against its own law, it is against the judgments rendered by the superior courts and the ratio decidendi, which is evolved and developed over the decades of this jurisprudence, this decision is also against all these judgments. So, in my view, especially the application of this decision, which is retrospective, that has undermined the fundamental rights of this qualification.